I am Sandra Colliver with the Open Society Justice Initiative. My team, including Mariana Moss and Danny Ikawa, who are here with us, we litigate and we build the capacity of advocates to defend and strengthen the rights to protest, freely associate, and access and expose information of public interest. We are delighted to be moderating the session today and delighted that so many of you are here in the room to join the conversation. I want to start by acknowledging the 8 co-sponsoring organizations, and I do this in tribute to all of you and to let you know who's with us in the conversation. The co-sponsors are Access Now, the ACLU, Article 19, Committee to Protect Journalists, Human Rights Watch, Columbia's Global Freedom of Expression Institute, Columbia's First Amendment Institute, and the Media Law Resource Center. And I'm just going to flag a few others of you who are here. AJWS, Brennan Center for Justice, Common Cause, Dangerous Speech Project, PEN America, Witness, Reuters, PillNet, the International Senior Lawyers Project, and a number of the graduate centers, NYU, Graduate Center of Journalism, CUNY, Cardozo. I want to thank you all for coming, and we're looking forward to moving through our initial presentations and getting questions from all of you. So a few housekeeping matters. This discussion is being videotaped. We will have a link available on the Open Society Foundation's website within a few days. So if you'd like to share that link with others who weren't able to join us, please do so. And if you have concerns about not being videoed, you might make your way to the back of the room to listen with us. We're keen to hear from all of you, so I'll be very brief in my introductions. Very pleased to be joined by David Kaye, the UN Special Rapporteur on Freedom of Opinion and Expression, and a clinical professor of law at the University of California, Irvine. David has brought attention to his role not only for the forcefulness of his statements about violations of these rights, but also for the clarity and directness of his statements, which are on display in this book that David will be talking about, and also in his reports, making them really enjoyable and I would say somewhat of a standout among UN often turgid reports and style. Next to David is Lynn Oberlander, Executive President and General Counsel of Gizmodo Media Group, one of the largest digital news companies in the United States. We may be interrupted from time to time by social media. That's one of the pitfalls that we're going to be talking about. How to control the intrusions. And finally, Misha Chowdhury, Legal Director of Software Freedom Law Center in New York and Founding Director of the SFLC, a legal services organization based in New Delhi that works to protect privacy and freedom of expression in the digital world. David, turn to you for some opening remarks, perhaps 10 minutes. And maybe you could also address some of the issues that are headlines in the news, efforts to break up the big tech companies, and what to do about dangerous speech.
All in 10 minutes. Yeah, great. So first, thank you all for being here today. And I especially want to thank my co-panelists. And I just want to start by saying something unrelated to the topic. So yesterday I had this opportunity to be at New America and sit between Anne Marie Slaughter and Rebecca McKinnon, two remarkable leaders in the fields of human rights, international law, digital rights, and so forth. And today with Sandy, Mishi, and Lynn, it's the same kind of thing. I'm with people who have really made huge impact in their fields, in our field, and I'm looking at Monroe Price here as well, and many others in the room who have just had such a huge impact, and R.A. Neer, I mean, really major impact on the place of freedom of expression and human rights in our world. So I just sort of with some humility want to acknowledge and my colleague Agnes Calamar. I mean, I could do this all day. I'm sorry, I won't do it. But really remarkable to see so many of you here. So I do want to limit my remarks to as close to 10 minutes as I can, because I want to give an overview of the book, in part because that's what my publisher would want me to do, but also because I think the book, which is this, Speech Police, what I try to do is articulate, maybe for a broader audience. I think this is an audience here in this room of real experts, people who've been thinking about these issues for many years, but also to articulate for a broader audience, not just an American audience, but maybe a global audience. But I would say especially for an American audience, two things in particular that I think are absent generally from the conversation about social media and online speech today. So and those two issues, I'll mention them first and then go into a little bit of detail. One is the remarkable power of the platforms. I think we in this room know that, but I think there's something more than just platform power that's at issue. It's platform dominance of space in many public areas around the world, in many environments. But it's also the massive bureaucratization and governing structures of speech that have developed by the platforms that I think have a very strong impact, not only on freedom of expression worldwide, but also the way we think about free speech. And one of my concerns is really that if we only think about speech in the context of the kinds of harms that are online, we might, over time, undermine our commitments to freedom of expression in the public space more generally. So I'll talk a little bit about that. And then the second part is, and again, I think people in this room know this, in response to this massive new form of platform power, governments have looked at companies and they're jealous. I mean, jealous in the sense that you might expect government to be jealous. And someone like Rebecca McKinnon wrote about this 7 years ago in her Consent to the Network. Governments are going to push back, right? They do want control of what they see as their territory or their citizens or their public space. And so right now what we're really seeing is, it's not just the emergence, it's been for a few years, but particularly in the last couple of years, an intense debate around how to regulate public space, how to regulate social media. And that's been particularly the case in Europe. I think it's actually been a robust debate, I think it should be a rewarding debate for many people who think it's important to have these things in public discussion. But in many respects, governments and the European Union have gone the wrong way in certain respects. And meanwhile, the rhetoric of kind of a dark internet and an internet of harms has also transformed the global debate into one of what are the ways in which we should govern this space? What are the ways in which we should restrict expression, rather than, as I think we originally, perhaps naively, like Bill Clinton, who famously said, in light of China's efforts to regulate the internet, really like 20 years ago, good luck with that. It's like nailing Jell-O to a wall. That's it's not apocryphal. There's a video. If there's a video of it, it's true, notwithstanding Nancy Pelosi's. So that's what the book is about. So let me just say a few words about each of those things, and then I'm really excited to hear from Lynn and Mishi in both their perception of these issues, and then obviously have a conversation. So first, in terms of platform power, I think that as we look around the world, we could, and particularly in a place like Open Society, and with all of the partnering organizations, we could come up with a very long list of instances where the platforms have contributed to all sorts of harms. Obviously, at the top of the list is Myanmar, but you could go down a longer list. You could even think about places like Kashmir, where the internet is regularly shut down by the Indian authorities. And in addition to that, authorities put enormous pressure on the companies to take down accounts, to take down content, and it's virtually opaque to users as to why their accounts have been taken down, as to why their expression has been restricted. So that in that environment, and I think this is an environment that is somewhat different than the US environment, right? When we think of the companies here in the US, we might think in terms of, well, if you can't get your content up on Facebook, you have another mechanism. You could go to, I mean, nobody in this room is going to go to Gab, I hope. But you can go to another platform in order to express yourself, or you have a robust media that might provide an outlet for expression or access to information. So we don't necessarily think of the impact in the same way as the rest of the world, where the platforms not only dominate public space, but in some places, the platforms aren't just the internet, but the platforms are public space. They are the place for debate. And so there is a kind of spectrum in which we can imagine the ways in which platform bureaucracy, that is platform rulemaking, like their community standards or rules, et cetera, around content, where it becomes more or less, or we could think of it as a spectrum from the least to the most impact, where those rules can actually have an enormous impact on individual access to information, on public debate, on public conversation, on humor and satire, on criticism of government, and so forth. So that kind of power, I think what we miss when we just look at that power, what we do miss is the nature of of governance that the companies are undertaking. They have these rules. They have, as Facebook calls it, a biweekly mini legislative forum where they actually gather together and articulate, as if they were a legislature, what the rules should be. They have tens of thousands of content moderators around the world who are making these kinds of decisions about what should be deleted, what should be ignored. So all of that is happening. And meanwhile, governments are pushing back. So let me turn to governments for a minute. So governments, and let me focus on democratic space for a moment, because I think that's, in some respects, it's the most interesting in a way, because the nature of the discussion in Europe in particular is really focused, again, as I said at the beginning, on the kind of rhetoric of the harms of the internet. And we've seen basically in 3 or 4 different areas where government is moving towards regulation. We've seen it in the context of terrorist content, hate speech, disinformation, those 3 in particular. And then, of course, there are others like child endangerment and child exploitation, which there's a general consensus around the world for there to be pretty strict regulation. So the problem, I see nothing illegitimate. In fact, it's fully legitimate for governments to look at this space and say there's a public policy, there's a public impact here, and therefore public law should play a role in this. I don't see anything illegitimate about that. The problem is the nature of regulation, in addition to the debate, but especially the nature of the regulation has been such as to in effect, empower the companies even more. So on the surface, it looks like government regulation, which is designed to restrain companies and to bring them into line with public law. In effect, 2 things have happened. One is, in part because of strict penalties under laws like Germany's new NetzDG law, but other sorts of pressures for content moderation, they're extremely expensive. And they're available mainly to the very wealthy companies, the companies with the resources to do this. So one effect of the regulatory push, which is a regulatory push without a lot of kind of public resources devoted to ensuring other actors, other kind of competition, it's basically increased the power in the market of especially Google/YouTube and Facebook. And meanwhile, the mechanisms that have been chosen by regulators, both at the national level and the European-wide level, the mechanisms have been designed to say to the companies, look, this is our law, this is law in Europe, or this is law in Germany, and we want you, companies, to remove content that is illegal under our law, which, again, in principle, is not that problematic. However, what it is basically transform the companies into is a kind of adjudicator of legality in these different environments. And that adjudicatory role takes place more or less, although there's the possibility of change, more or less without the input of public institutions, without the input, for example, of courts actually making the determination as to what's lawful and what's unlawful under the law. So the power has been increasing for the companies to serve this kind of adjudicatory role, which removes democratic accountability. And so, and I'll wrap up here, again, without getting into current controversies I assume we can get into in Q&A, but where that in effect leaves us is when the companies make decisions, and part of this is by design, because there's the e-commerce directive, which is similar to Section 230. I mean, there are differences, but in the providing immunity from liability for the companies. So part of this is by design and is important that the companies don't have liability for their decisions around takedown. But what it has meant, or for leaving up content, what it has meant is there's no democratic accountability for these major decisions that companies make that have a very significant impact on individuals, on public life, on public institutions. And that's, I think, the real question and the challenge, I think, for the many of the people in the room who think about these issues. How do we think about inserting public accountability and democratic accountability to these really important issues, and that is to deal with some of the harms of the internet without at the same time damaging the good of the internet, right? All of the things that we originally loved about the internet, which was access to information, democratization of debate, the greater access to for individual voices to be heard, all of that. How do we achieve both of those things? And I think that's a real significant challenge, a significant public policy challenge for not just for the United States, which, footnote, we're hardly having this discussion in the United States. It's a discussion that's taking place in Europe. And it's a question that I think we should all be grappling with as we think about what we want freedom of expression to look like in online space in the coming years. So I'll stop there and turn it over to my co-panelists. Thank you.
Great. Thanks, David. So Lynn, you're general counsel of one of the largest digital news companies in the United States. How do internet issues and governance issues affect your work? What's the impact of the regulations coming out of Europe? And if you do want to take on, what do you think about the current efforts that are being launched to start to address antitrust concerns?
So what I will say is that these are all my opinions, not the opinion of my employer or of any previous employers or any future employers. It is definitely something that we deal with every day, right? Before I answer, let me just say that the book is fantastic. It is exactly what I wanted to read. It does sum up all of the myriad of problems with the internet, and I was racing to the end to find out what your solution was, which I have some questions for you later about. But it is a what's that? I'll show you the book. Here's the book. Everyone, apparently they're not for sale here, but I encourage you to purchase them because it's also very concise and it's really great. And one of the things you say, and this is an answer to what you're saying, Sandy, is that so right now, as we all know, we have Section 230, we have the DMCA, we have all of these things that have not allowed for any kind of intermediary liability and have allowed the internet to blossom and we have a very, very, very active commenting section on all of Gizmodo's sites, and it is definitely one of the reasons that people come to our site, and it's good for business. And we would like to keep that. And yet, I think we all know, many of us know at any rate, I don't want to speak for everybody, that Section 230 and that kind of immunity has created an enormous number of the problems that we are talking about here. And that if we didn't have that kind of liability, if we had some sort of publisher liability for the stuff that was on the website, we wouldn't have the same hate speech issues that we have. We wouldn't have, we might have some of them, but we wouldn't have the enormous amount, the whole devolution of public debate. So I think I actually want to sort of ask you about that because I think that one of the solutions might be to bring back some level of publisher liability. It was created by legislation, and that kind of immunity doesn't stand for any other types of mediation. And then the other, the other regulations that are coming out of Europe, particularly are incredibly problematic from an American perspective. And I know this is a big human rights audience, and I know we clash on the value of privacy or privacy versus freedom of expression issues, but the right to be forgotten, the GDPR legislation. So I'm sorry. Yes. So the right to be forgotten, GDPR regulation, all of them are. I mean, it's a very different approach, as you all know, to the American system, and they're very expensive to comply with, but okay, people can figure out how to comply with it. But they are really in strong opposition to the idea of the First Amendment, and that if you go bankrupt in 2006, and a newspaper writes an article about that should be available in 2016 or 2019. And so it is just, I mean, as many of you know, the GDPR seems to be coming, and the right to be forgotten is coming in various forms. It's happening, in California, you have the erasure law for minors, and you have regular attempts in New York State and other states to create expungements of people's criminal records and to penalize the reporting of those criminal records. So it is coming. But to your question, Sandy, to directly answer, I mean, that's, it's a problem. Even though I think as an individual, I like my privacy too. I don't like the fact that everything I do and everything I buy and every place I walk is being tracked. I mean, that's incredibly, and sold, tracked and sold. So, I mean, I put that, and your book doesn't really talk too much about data privacy issues. It's really much more about speech issues. So I do, so to answer the antitrust, and then I'll let Misha talk, because it also is a question I have for you. Your final chapter, your solutions chapter, is titled Policing Speech in a Centralized Internet, or Centralizing Internet. And so the idea of this incredible power that has come to these three major platforms, maybe add a fourth to it, seems to be not just that seems to be the major problem or the major cause of many of the other problems, is that you have these enormously powerful private actors that are both American-based, but have this power internationally to govern everything that we do in all of our speech. Why isn't the antitrust solution like the best solution across the board? Break them all up so that instead of having these three, you have 50. And won't that solve? This is my question. Won't that solve a lot of the issues of centralizing of power and of one person making these, or one company, or Mark Zuckerberg or his content legislators making all of those decisions? You break them up. Maybe you have a lot of different deciding private actors making decisions about what kind of speech they're going to allow on their platform. So that's my question for you.
Great, thanks. So, Mishi, what's the perspective from India? You practice law both in India and in the U.S. Maybe give us a sense of some of just a few of the issues that you've been litigating, and then how are these internet governance issues impacting you?
My views are of my employer, but not of my clients. So internet was shut down 134 times in India last year. We're in June. 48 times it has been shut down. It matches the current weather in degrees Celsius in Delhi right now, 48 degrees. People are regularly put behind bars for saying unpleasant things and sharing memes of politicians. That's happening every day. So this election in India, which we have just ended, small election, 1.25 billion people, 950 million voting. This was not about censorship. As much as we'd like to believe, it wasn't about free speech and expression. It wasn't about censorship. India is not the place we should be, or India is not the only place we should be looking at for that. If you want to know what is going on, really, you should read this book, share. But also you should be looking at who is raiding the offices of the broadcasting corporations with the help of federal police in Australia. If you want to understand the threats to free speech and free expression in the world, just don't look at the bad ones. Look everywhere. Look all the time, everywhere. The President of the United States recommends boycotting AT&T in order to punish CNN. David is worrying about a problem which is seriously in danger across the globe. Respect for free speech and expression is at its lowest point since the Second World War. We know that's true. Yes, there was Soviet Union which existed at one point in time, but the Chinese Communist Party has outdone anything Soviet Union was ever capable of. Corruption is everywhere. Viktor Orban's friends are buying all media. Tsar Vladimir controls everything. Indian press is venal. But David is one pursuing its global meaning. What does all of this mean for all of us? If global government principles, human rights, have any meaning at all, we have to save free speech and expression. And we cannot save it by bundling all of these issues of Facebook employees in Philippines. We are lucky to have a relentless crusader who can keep his eyes on the prize and keep fighting, not because we can win the fight in a short time, but because the alternative is horrible. And that's why this is so important. And that's why I love his work and his book. Having said that, there's always a but. Obviously, I'm going to disagree. Practicing in 2 jurisdictions also tell you how disillusioned one part of the world can be about many principles which they take for granted. First Amendment is great. Falsely, a large part of the internet population believed they all had First Amendment, but that's not true. India's First Amendment actually restricted our rights of free speech and expression, the First Amendment to Indian Constitution. I do have to say, for all of us who are not in David's enviable position and tasked with this simple thing, free speech and expression, we are living in global warming on internet time. That's where the tech problems are. We don't even have until 2040. So we know that the companies, the jig is up. At least all the companies know that, we know that. They all know that period of unregulated behavior is over. Not a moment too soon, because they also understand the extent of the ecological damage they have done. Denial is no longer going to work. And at this point in time, we are in this negotiation mode. All of us, the society, the civil society, governments, and the technology companies. The governments also recognize that no matter how jealous they are or how much they wish to take the advantage of social media, they cannot keep calling it innovation and also not acknowledge the harm they are doing and the companies are doing. In the global south, whether we are in India or in Brazil, we know WhatsApp and its infinitely usefulness to political parties to win elections is a real thing. New York Times is just waking up yesterday to realize how important WhatsApp is. We've been telling you, 34 lynches in India because of messages which have been circulating. But obviously, we're a small country, 1.25 billion people. So that doesn't matter. It's true that 50,000 groups in WhatsApp groups, 256 members each were created in one state in India to run these elections. We do not know when those buttons are being pressed, that communication is encrypted, it's being weaponized by political parties, what's really going on. That's the time when I cannot put on my US hat and keep shouting First Amendment, or free speech and expression. That's why it gets a little more complicated. Everybody can see that. We know that it's a problem. The Indian government went into the elections promising a very soft deal for the use of government identity information, all the information with biometric data of Indians, to say, we will offer this to you, the use by the private sector if we win the elections. They have won the election. We cannot take for granted that the Indian Supreme Court's attempt to restrict the use of this biometric information for private use is going to work now. Now it has opened the floodgates for use of Indian personal data in commerce in India. India has also set up regulation, data protection, data localization to create what we would call here the Wild West, but it's going to be limited. Indian data now belongs to India, which translates that Indian people belong to Indian businesses, not the American businesses. This economic nationalism and a determination to create an unfettered society beyond cashlessness, beyond privacy, is where we live in India right now. And the current government is going to fight the American platform companies in favor of the Indian platform companies. And that's the promise which was made by the current government to the businesses. Yes, this means that there will be litigation, which the government will call dubious or anti-national, or various other pressures would exist for a lot of us. Yes, there'll be a lot of issues here. But what is going to happen is also that they're going to keep pushing, because the amount of money is much more and much bigger than what is at stake. If all we lose is a special status because President Trump is angry and $6 billion in exports, we no longer care about that. Data is far more important. Maybe later, and which is what I think Lynn already raised, the interesting thing is we're already on the negotiation table, but society does not really have a great place here. It's, again, the fat cats making deals with the governments. And that government this time is not just the US government here. And antitrust is great. It'll drag on forever. It may or may not do everything. It's firm-specific. And we do not know at the end of it what will happen. We know that the European Commission will do this because the regulatory posture is what European Commission does best. We also know that other people are not so capable of. But just threat to take away 230 liability and then see who all are at the negotiation table. I also think that the reason for 230, which was coddling nascent industry, no longer exists. They are such powerful businesses right now that the very fact that we gave them enough power to become the largest media distributors to actually broadcast live murder is something which is astounding to most of us. So we can stop buying into their free speech wing of the free speech party and actually come to reality that they're so powerful right now that perhaps the federated systems and the removal of decentralization and changing the market forces for them is what we must do using the biggest bang for our buck, which is take away the 230 liability, immunity from liability.
David, well, there's a couple of challenges there. The privacy issues, the liability issues, how to break up the internet. If it's not broken up in one way, there's the specter of nationalist control. I'm sure you give us the answers to all of that in your book.
No, I don't. So, wow. Okay, so these were some, as expected, Lynn and Mishi, you put on some really important issues put onto the table. And I don't think I can even begin to scratch the surface of the depth of your comments. So I just want to maybe address two in part so we can start a conversation, and then presumably people will want to engage also. So one is antitrust. So I don't have I admit, I don't have a firm position on competition policy, in part because so far, at least in the US context, the competition discussion, and I think this comes through really quite starkly in Chris Hughes's op-ed in the Times, is an argument about how to benefit American consumers and American users. And I guess at this point in time, my concern about the antitrust debate is that, and maybe to back up slightly, I mean, I've been using this you remember how Colin Powell in the run-up to the Iraq War said, you break it, you own it, which apparently is not a Pottery Barn rule. But I mean, I think the rule here is something more like, you built it, you own it. And so the companies have a kind of responsibility now that isn't limited just to, well, what happens if you break up the companies and you break them up and you get some benefits in the US market? I don't know quite what the implications of competition policy would be for the, say, 85% of Facebook's user base, which is outside the United States. So just to give an example, and I think most of the competition argument or discussion has been, not in some comprehensive like Ma Bell kind of approach, but more in terms of separating Facebook from WhatsApp and Instagram. If that's, to me, that's pretty limited, right? But what that could also mean, this is just a speculation more than anything else, is that, so WhatsApp now is basically a fully subsidized unit, sort of Facebook in a way, and so it's free, right? And there are a lot of benefits to Facebook, to WhatsApp, a lot of downsides to it. But what I do wonder is, because WhatsApp has been such a huge tool for all sorts of reasons around the world, what happens if they no longer have, like if they have a need suddenly to create their own business model, and so they have to charge for it? Just as an example, that might not be a problem, but for a lot of people around the world, the implication might be that they no longer have that tool. That might be a good thing, because then maybe more people would go to Line or Kakao or to other tool, or to, one could hope to Signal or something like that. But I think that's just part of our conversation excludes the global. And I think so my reaction to the competition question is, yes, it could be part of the discussion, but I don't think we fully thought through what the implications would be given the fact that the companies are global. Okay, so the second part, and there's more to say obviously about competition, because I also don't think it really does, if it's that limited, I don't think it resolves the online speech issues that Facebook in particular has to deal with. So on Section 230, and we could also think of it in terms of e-commerce directive and intermediary liability. I guess the way I want to think of it is, I just want us to imagine the world, because every question here is about trade-offs. So I want to imagine the world in which the companies are liable. I mean, if we're saying literally get rid of Section 230, what does that mean in terms of the liabilities that the companies face for all sorts of content decisions, whether it's to leave up content or to take it down? And I guess my concern is that the incentives for the companies will be to take down a lot of content. Now, that might resolve some of our problems or some of the concerns that we have over the harmful content, but it will also mean that the companies will take down a lot of the content that we tend to like to see on the platform, or particularly people who do a lot of work around human rights and advocacy around the world. A lot of the content, I think, around government criticism, around reporting, like a lot of that stuff, the companies will likely, decide to take down. That might be an appropriate trade-off. I mean, the harms might be so great that's what has to happen. But I think in the absence of immunity, that we begin to enter a world where it's not just social media, because presumably it would be internet-wide, that we begin to lose the original promise of the internet. Again, maybe that's the price we need to pay, but I just think that we need to be, cognizant of that result from losing that particular protection.
Lynn, would you like to?
Yes, I have a question for you about, so what you've done in the book, I think, and with your solution, I completely agree with you about this, is that you've taken the situation as it is, in the sense that we have this regulatory system and we have these huge companies. You have laid out the real problems of these private bureaucracies that are not transparent and are making enormous decisions and are responsive to, they're responsive at some level to public pressure, they're responsive to governments in different places, but you don't exactly know how it's working. And you have tried to come up with rules that, given the system that we have, yes, would make it a little bit better. Mm-hmm. So I see it. It's not radical. You didn't say let's radically change the structure because of this is what we have here. I guess I do have just a question for you about, so you ultimately say that human rights law should govern sort of content decisions in the end of the day, and decisions about what comes up and what comes down. And this is a very American approach, so I appreciate that I'm not talking about what goes on in the rest of the world, and it is 85% of the global industry, but how would that work? How would that work domestically? Would you say, well, right now, the platforms have policies that you can't have hate speech. However, they define it, and they define it in all different ways at all different times, and in not any kind of clear way. But of course, under the First Amendment, you can still go to a public square, a Central Park, and you can espouse as much hate as you want to, and that's completely protected speech. So how would you use the human rights law to solve that issue, I guess?
Yeah. So it's, first of all, you're right. I'm basically, the book is accepting, and I wouldn't even say reluctantly. It's accepting that the world of social media, it's here right now. And like Mishi, like you said, any of the potential solutions like around competition are going to take some years to resolve. They'll be litigated and so forth. So I think there's an imperative to make change right now. Facebook is continuing to rise in value. Apparently it's still popular. If you have teenage kids, it's not, unless their school requires them to have a page, right? But otherwise, I basically am proposing a set of ideas that they're not shocking, they're not radical really, but I do think some of them could have an impact, at least over, let's say, the near term of the next 3 to 5 years, and shaping this world as it exists, and I don't think it will change significantly over the next 3 to 5 years, let's say. So, one is human rights standards. So when I say human rights standards, I mean the companies should root their content policies in international human rights law. And I think there's a lot within human rights law. I think it's, we often look at, hate speech law or something and think, oh, well, Article 19 of the ICCPR doesn't tell us that much. But there actually is quite a bit of jurisprudence around, and not just in regional courts, but also in national courts around the world. I think there's the capacity for the companies to develop standards that are rooted in human rights law, and that for me that's a first order. Root them in human rights law. I think that in an instrumental way also gives the companies a better basis to respond to government demands, which we haven't really talked about here. And I think that is a major issue here, which is governments are increasingly putting demands on the companies to take down content, and the companies respond with, what, our terms of service say blah, blah, blah. But that's discretionary terms of service. That's rooted in their business interest. If at least they rooted it in human rights law, look, it's not like the governments are gonna say, oh, I didn't realize our citizens had human rights. That's not gonna happen, but it creates a little bit of friction, which I think is important. And you couple that alone isn't going to help. If you couple that with transparency, and transparency I don't mean in a generic sense, I think the companies should be much clearer and provide much more disclosure. And this is actually an area where I think government regulation is totally legitimate, is to require companies to disclose more, not just around their rulemaking process, but also around their decisions. I've called it a kind of case law, a case law of content decisions, which, GDPR makes that harder now, and there are obviously other privacy rules, but I think there's a lot more that the companies can disclose, and if you pair that with some other principles, at least we get a little bit further in terms of providing some sunlight and providing a kind of sense of less of an asymmetry in information, so that these debates can happen on more of an equal footing. Right now, we don't really know how the companies are making these decisions. Everything seems, although it's real, I don't think it really is, but everything seems seat of the pants, ad hoc, and so forth. We need to have a better sense of their decision making. And then the last thing is there needs to be oversight. There's no question that there needs to be oversight. It might be governmental. I personally prefer the idea of multi-stakeholder oversight. There's some ideas out there. Article 19 is really articulating this idea of social media council, which is kind of multi-stakeholder, industry-wide oversight of the companies, which is not just mere appeals, but really trying to root some human rights standards into these different kinds of decisions that the companies are making. So those are a few of the things, but Lynn, you're absolutely right. This is not a book about, radical change to the system, although I do have a belief in the kind of possibility that if you create some structures that push the companies in certain directions, and you let those structures be independent, and the companies buy into, and this is the hard part, get the companies to buy into some of those mechanisms can take on a life of their own, and if they're heading in the right direction, they could create a kind of momentum and pressure that can be beneficial. But I'm also not naive, and I'm not sure these things are solvable without the kind of radical change I think that you're both alluding to.
All right, thank you. So turning now to the audience, we have a fixed microphone up here at the front. I'd invite people to come and form your questions. I'll take 3 or 4 at a time, and I'll also, if there are more questions than that, I'll take hands and keep a list. So the fixed microphone is here. Andrew, you had sort of a call out to Article 19, if you'd like to start us, and then please come and stand behind Andrew. We'll take the questions and several at a time. And please introduce yourself and your organization.
Sure. My name is Andrew Smith. I'm the head of our UN advocacy team in Article 19, Freedom of Expression Organization. I had 2 questions, again, that don't necessarily reflect our policy stance on these things, but things that we're thinking about that perhaps are provocative. When it comes to international human rights law as the standard for the substance of the content moderation, this is a set of norms that isn't static, but it's being developed. And I wanted to sort of get the panel's view on the contestation that exists within international human rights law between states and what these standards mean and how that might affect companies' conversations with those states, and perhaps specifically how the United States has left some of the forums such as the Human Rights Council where these norms are developed and has just established a commission on reinterpreting international human rights law. I didn't realize this wasn't on until that second.
Can you repeat that?
Yeah.
Start over again.
It would have been helpful if the microphone was on. I didn't notice that. Sorry about that. So yeah, just about the norm development around the contestation and the fact that the US has left these spaces while initiating discussions that really question the validity of international human rights law in the first place. And then secondly, around the oversight, and I think that there's perhaps an assumption sometimes in these discussions that an international human rights law approach to content moderation is the same as a harm reduction approach. But the reality is that if, at least as Article 19 sees the standards, if we want social media companies to be applying those content standards, it's going to mean accepting a lot more harm on those platforms in terms of allowing harmful speech that we don't want governments to restrict. And it's going to be often minority groups that bear the burden disproportionately of those harms, including to their freedom of expression rights. So does that mean that we should be asking those companies to develop more ethical standards that deviate somewhat from the restraints that we expect to see on states in content regulation? Thanks.
Great. I'll ask the next speaker. And can you hear now the questions? Yes. Okay, great. Maybe just tilt up the microphone a bit and please introduce yourself.
Madeline Earp. I'm the technology editor at the Committee to Protect Journalists. I worked on the Freedom on the Net report, my Freedom House, for several years. Sure. My question is actually for Mishi. I have been used to pointing to India as an example of somewhere where intermediary liability has been very problematic in the past. And so I'm very interested in how we turn the conversation from liability more towards kind of accountability. But India has always been somewhere where I've said, look at what happened in India before they, made the adjustments to the law to improve the situation for companies. So I just really welcome your views on that. Is that wrong?
Thank you. And I'll note we've got 4 questions here. Nobody else should come to the mic. I'll take hands. We can take 4 questions now.
Okay. My name is Dr. Friedlander. I'm a political scientist. Now, before I make my question, 20 years ago when we thought of the internet as a force for democracy, it was an internet that was non-commercial. In other words, it was not the internet today. No ads, nothing, no business. It was just free internet. Now, today, when it comes to determining content takedown, it's determined by AI. AI is dependent upon past experience. Something new happens, AI is not going to deal with it. How do we actually respond to the fact that the first step is AI in terms of the internet? And for you, what is your response to Senator Warren's recent statements of literally breaking up the internet companies?
I thought you were going to answer the question. Well, thanks for the quick opportunity. I'm sorry. Charles Glasser, a professor at New York University Graduate School and CUNY Newmark Graduate School of Journalism. And I'm also a media litigator and attorney and troublemaker. I write a couple columns for various and sundry outfits. I'm curious, going back to Section 230, and what I wanted to ask was, could this possible spectrum be laid out as follows? Because I've not read your book yet. I look forward to it very much. You may be aware of the fact that a number of people, particularly people who identify as either conservatives or civil libertarians, are bucking their free market pals and arguing for antitrust regulation, not so much about market power, but rather as a jurisdictional hook by which to apply the First Amendment, because as we know, the First Amendment quote doesn't apply to Facebook. This would allow it to do that. That being said, I wonder, and I would like to hear between you, because I personally have, Section 230 hasn't worked out in some cases quite as well for journalism anyway, or for public information. Jones v. Dirty World is one of the craziest, both the trial court and the Sixth Circuit, one of the most insane decisions I've ever read. And the question of intermediate liability, there's got to be, I ask you if there is, or can you foresee, if there is a jurisdictional hook, rather than appealing to, say, ECHR standards, but if there is a jurisdictional hook by which the First Amendment can be applied, right? Well, then it's simply a question of narrowly tailored to achieve a compelling public interest. And in that case, there's some compromise there, where the social utility of the speech is questioned and all that sort of thing. And it would allow the people you hate, like Gab. I don't know what you've got against Gab other than you disagree with them. I mean, they're right-wing nuts. They're nuts. But, right-wing nuts are entitled to be right-wing nuts, as Lynn pointed out. The other thing I just couldn't help it, I have to mention, I was in Chhatarpur. Americans don't understand how popular WhatsApp is in India. They have no idea. And I was in Chhatarpur when a riot broke out because one group had said something about Hanuman that the other group disagreed. Hanuman being the religious character, leave it at that. It was quite remarkable. But the question for you, I'll get away, is there a way to establish a jurisdictional basis, whether it's the First Amendment or the ECHR or some other right, and then apply an intermediate standard, intermediate as opposed to just doing away with 230, because we can't have that. We can't do away with 230. We need a more Jankowski, an immuno sort of escape hatch. Your business, Gawker was founded on a community of commenters, and it was a brilliant, Liz Spears, and it was a brilliant model. And anyway, I think you get what I'm getting at. Is there an intermediate way to save 230 on a global scale? Thanks.
Thanks for all those questions. I'll ask Mishi to start, and then David, and then Lynn. And also for the next round of questions, I hope maybe we might hear from Agnes and Jamil, maybe Alex. Keep thinking about questions, and we'll get back to you in the next round. So Mishi, please.
Okay, so when I said we are at the negotiation table, antitrust is a great opener, and the companies and everybody's paying attention. Obviously, Senator Warren said what she said, but because it's going to be so cumbersome, dragged along, and various other issues, and it will only address a small problem in this very small country, 350 million users. That's why I say, when I said, let's get rid of, or even the threat of removing the immunity from liability will get us to have an actual conversation. Removal of liability will not mean strict liability for everything. Yes, a lot of states' tort legislation will kick in, and yes, every state will have some, and courts will develop what they did. But we also know once California started doing CCPA, everybody wanted a national legislation on privacy, which was not happening earlier. So I'm only saying, let's just get smart, and we have lawyers on our side, so the society can also say something radical, because things have become so bad that all this thing about we should have a little bit here and a little bit there is not going to help us at all. Now, so yes, it will develop into something else. I do not know what that thing is to save 230, but we should understand 230 was for a particular reason. We don't live in that world, and I'm very grateful for the lady here who brought it. I cannot think about free speech and expression divorced from the idea of behavior collection by the platform companies, by the telecom service providers, who all want to collect all kind of data, monetize it for all the purposes they would like, and they can pretend on the side to do fact checking, to do all this oversight board, etc., because it works for them. And the entire advertising business is two companies. So if we're going to have these conversations in separate silos, we won't get there. And I'm right now saying there's a lot of noise, but just the threat of saying that gets everybody's goat in a very different way. That's what we saw in Europe. Now, coming back to the question about India's intermediary liability, and that's what I will address. David is right, and that's why the book is important, because it takes a view of what's happening globally. WhatsApp has currently 250 million users in India. That's the biggest market for Facebook. They don't care about any other market right now. And David is speculating, but he's also right about the fact they're already in negotiation about monetizing that model. One of the big problems Facebook has faced in India right now is that they want, this is where the Chinese models are so attractive to everybody. With no regard to human rights, etc. It's the same thing about trade. We thought China will open up, and we know where we are. And because WeChat is this platform which is so attractive to Facebook and WhatsApp, they want to turn WhatsApp in the rest of the world into a WeChat. They have been negotiating with the financial regulators in India to introduce payment systems, business advertisements into WhatsApp. And because it hasn't gone very further up, and there also has been the issue about whether we want end-to-end encrypted communication and what would be given to what the government demands, that's why it has stalled. That is already happening. So the companies are going their way. Intermediary liability, and you're right about the fact, considering I fought in the Supreme Court 2 matters on intermediary liability and worked on it for 10 years, now I think about, of course, like the companies, I have also evolved. I just don't have that kind of money and power. And what she's referring to is rightly so, is that before the immunity was provided to Indian businesses, they were arresting CEOs of various companies for something which was sold on their platforms by X person or Y person. Now we fixed that. We had to go all the way to the Supreme Court, talk about these issues, and there was also an amendment to the legislature. But I still make a ton of money by representing small and big platform companies who are always in court talking about these issues. And the Googles and the Facebooks can afford that litigation, but not the others. I will also say, which might come as news, that Google and Facebook don't behave the same way as they behave here. In India, they tell all the time, the governments, we can't give you anything, lex loci server. Our servers are in California, we can't give you any information, go away. Now that means when there's an actual killing and they're asking for information, and Facebook and Google are going to play this game with them all the time. Now, people like us who want to talk about free speech and expression, who also understand the censorship by proxy, which is what the government wants to do, tell these intermediaries to censor so that you can't take them to court. Because every time right to free speech is only justiciable against state, not private parties. And they want to do it this way. But when they do in actual matters, they go through the MLAT process. Now, of course, the Cloud Act is there. And the governments are like, so 34 people will get killed. You will not even give us metadata. You will tell us to go get the data from California. And you're going to litigate with us. And then you want this immunity. So the governments are going to push as hard as they can on both sides. The citizens do get squeezed. The companies do have to face, there are new rules about intermediary liability. But I do have to say the conversations are not as transparent or as honest. And this thing about, oh, we just want free speech and expression, I also think this is something co-opting a lot of civil society by the technology companies. Go talk about our free speech and expression rights. Oh, you poor people, your free speech and expression rights would be taken away if you don't talk about our immunity. I also think if we actually took away their immunity, they will at least be forced to think about better ways to create federated services and also separate the centralization of the advertising business model from that. Yesterday, YouTube decided to remove a lot of extremist content. What has changed exactly? What has changed is that New Zealand and the French people are telling you, you better pay attention and stop doing and stop mugging around with all of them and say we have to protect everybody's thing. Yes, right-wing nuts are entitled to its expression just as the left-wing nuts are, but this is just not about expression. So I'm just saying is that I still use those arguments, but India is a much more complex place, and these current liability regime and the way the companies are playing, it's so much more complex and evolved now that our dear and these human rights arguments, which I really want, and that's why I'm very grateful that David does that work, but I'm not sure that I can actually argue if I'm being conscientious and also being honest, that if everyone else is not honest on the table, and companies are definitely not. So, and let me also say, China is an actual competitor in the market. It's a destructive force because they are creating despotism. But right now, America, I do not know how many people know ByteDance or TikTok. That's the biggest social media platform which is growing right now in the other parts of the world. So the winners are Jack Ma and Mukesh Ambani. And half the population of the world is going to be deciding this while we are still debating for 5 years, shall we have a little bit different 230 or shall we have a little bit different First Amendment arguments? And facts are being created while I have watched 12 years gone by and nothing has changed. Sorry.
Well, thank you, Nishi. Great to hear this very interesting perspective from India. David, please.
So, gosh, I mean, there's so much in what Mishi said. There's so much in the questions. I feel like I can't answer or respond to both of those sets just because they're deep sets of questions. So I'm gonna answer a couple of the questions that were posed in a way with maybe sort of not definitive responses. So for Andrew, just one of the questions that you raised, which was, I think, articulating this concern that allowing greater reliance on human rights standards might allow for greater harms, right? That human rights per se allows for more speech, right? And by that meaning more harassment or things that are shy of incitement to violence and so forth. And I guess I'm not totally convinced that across the board that needs to be the response, right? So it's funny that you say that in a way because the American response to human rights standards is often, well, you can't have human rights standards because the restrictions are going to be so intense there'll be no speech on allowed. It's just such a bizarre, clash of vocabularies in a way. And so, when you look at both Article 20 of the ICCPR and you look at the restrictions that are available to states under Article 19, paragraph 3, and I think it's possible to conceive of social media as providing, or at least for the companies to use some of those restrictions in the way that they can still deal with the harms, right? So they can still deal with some of the harm. So for example, mere harassment in a public square under the First Amendment is virtually impossible to eradicate, let's say, and eradicate is the wrong word for all of this, right? But to mitigate. It's just very difficult under a First Amendment framework to deal with that kind of speech. But in a social media context, harassment is actually designed to eliminate voice, right? So it's actually designed to interfere with the right of a person to express herself or himself. And so I think it's available for us, and we're at the beginning of thinking these things through, I think, but it's available to us to kind of conceive of social media space and harms, like speech harms and impact of speech as having impacts that human rights law can deal with that we might not think of in a kind of straightforward way, just looking at what the European Court has articulated over the years. And certainly not as Americans might kind of caricature what human rights law is. So I guess I'm just not as convinced that human rights law needs to be this sort of, as you put it, sort of, you didn't put it this way, but kind of a free fire zone for speech. I don't think it needs to be that way. I think there are ways for us to start to articulate it in a different way. And in particular, because I think as Mishi really articulated really well, there are harms on social media that are not left to the online space. They also go offline. But I do think that the human rights approach is one that allows us to at least, rather than think about this only as a question of policing, but allows us to think more, maybe in a more considered way about the trade-offs that all of these questions involve. And that's in a way where I want us to be. I want to give more time for questions and also to hear Lynn. So I want to respond to one point about AI that I think it was Dr. Friedlander raised. I'm not sure. Yep. So you're absolutely, both of your points were absolutely right. We had a free internet, years ago. We had a decentralized internet, which I guess the marker that I'd want to put down, and maybe this is sort of the federated kind of question or point that Mishi was making too, is like it would be nice to figure out ways to go back to a kind of decentralized approach. There are things like Mastodon out there that allow for some of that, but they're not very popular, and so network effects are problematic. But if we could figure out ways to get to that decentralized space, I think that would be a strong push forward for many of these issues that we're talking about, more of a structural approach. And antitrust there might be part of the answer for sure. So the issue on AI is, so you are right, so AI, and given the enormous amount of data, of content, of user-generated content that is being uploaded to the platforms on a minute-by-minute basis, they really don't have much of another mechanism to surface content that interferes with their rules unless they hire 2 million content moderators, which there's no crocodile tears for Facebook. They're making money. They can hire, I don't know if they can hire 2 million, but and that's just, I'm just pulling that out of a hat. But it is a necessary tool for them. So what concerns me on the AI front are two separate things. So one is, we still need rules. AI still needs to be, let's say, fed by substantive guidelines as to, which direction the algorithm presents the material, the content. So it doesn't, it's a technology solution, but it's not a values or a rights solution to have AI. We still need to have the conversation about fundamentally what should the rule be. The second part is that it's actually two parts of the AI problem. One is it's incredibly opaque, both in terms of the technology, which for many of us is going to be opaque no matter what we're told. But it's also opaque in terms of the data that is informing the algorithm. And we have very, very little input into the data that's feeding algorithmic decision making. And I think we need more of that. And related to that, the algorithm is directly tied to the business model. And so this also goes to your first point about a free internet. And so when you have algorithmic decision making that gives individuals virtually zero autonomy around their information environment, we have a very serious problem. And so there have been some ideas floating around there about providing not only more insight into algorithm, but also identifying ways to create markets for algorithms and giving people more of an opportunity to identify how they can construct an information environment that is more open to their needs and desires and so forth. I mean, some of that is fed by our own choices and by the tracking and so forth that is following us around. But to the extent we could start to have some discussion around providing greater autonomy to individuals in an AI-driven environment, I think that's going to have to be a key part of the problem as we move forward, because AI is, I think as you're correct to state, is increasingly dominating, and the companies tell us that, right? It's increasingly dominating the way they think about solving, I should put in air quotes, solving, because I don't know how much good faith there is in solving the ultimate problems here, but they do say that this is the tool that they're going to use.
Great. Thank you. Lynn,
I'll be very quick because I know we want to get to other questions. I just want to point out that on page 64 of the book, David actually addresses AI, which I had made a note of, so I'll just read the paragraph. And then which is, and worse, company confidence in proactive moderation is feeding into government imaginations of the power of AI to filter all sorts of expression at the point of upload. Repeatedly, European leaders expressed the belief that AI can solve public problems such as hate speech, terrorist content, disinformation, copyright infringement. This belief is feeding into the age of AI, which risks an age of content regulation largely hidden from the tools of public accountability. So it's all here. But the other just note on what Mishi said earlier, and also what you said. I mean, you suggested that everyone should use Signal, which, I have Signal, I use it occasionally. And Mishi pointed out very clearly, the harms of end-to-end encryption means that it is completely not transparent and it's not subject to the rules of law. I mean, we saw that with the Apple, the Apple phone, the iPhone, but you see it with all sorts of conversation. And if you can't figure out what's happening on the encrypted WeChat or the other one, then you just can't find it out. And that is a real lack of transparency. And to the degree we're talking about transparency, there is a real tension there. So that's all I want to say.
Great. Thanks, Lynn. Alex and the speaker just, okay. Well, I'll start with Alex and he'll be number 2. And are there some more hands?
This is Sandy's Socratic method, right? You're next, Alex.
Thank you for selecting me to ask you. My name is.
I see Jamil. Let's see how many. 4. You'll be at the back row. Number 5, I think, and 6. So we're going to take 6 questions. I apologize that our time is running short, so I'll ask for quick questions and then a final round of responses from the speakers. Thanks,
Great.
Alex.
Thanks, Sandy. My name is Alex Abdo, and I'm the litigation director of the Knight First Amendment Institute at Columbia. Thank you for this great conversation. I'll be brief. Two quick questions. One is, to what extent do you think the problems we've been discussing today are attributable to the presence online of speech that could, permissibly be designated as illegal? And to what extent do you think the problems we've been discussing about are attributed to the fact that the platforms prioritize what is perfectly lawful speech in a way that creates societal harm by, for example, privileging sensationalist but shallow content over responsible journalism, for example? And this is relevant, I think, to your point, Mishi, because if you adjust the rules of liability, you're likely to address more the first set of problems, or the presence of illegal speech, and perhaps less the second set of problems, which is the ways in which the companies prioritize this information. And if you think the latter, then if you think the latter is the bigger problem, and this goes to something you said, David, would the instinct then be, instead of focusing on what's illegal online, focusing on the business model itself that drives this prioritization, and maybe focusing on finding more federated solutions? And if you're focusing on a federated solution, what about unbundling the services, as some have proposed, separating the network itself from the services that lie on top of the network, like the news feed, and opening the network itself to multiple companies who could compete over the views that you use to see the data? Do you think that's a promising solution, setting aside whether it's politically or legally feasible? Thanks.
For that question. Next.
Hi, Catherine Larson. I'm an editorial lawyer at Reuters. David, you mentioned Myanmar at the beginning, so I was curious what your thought was on regulating Facebook in Myanmar, where you have a country that's participating in the hate speech and funding it to a certain extent, so is not particularly interested in getting involved, and you also have. Oh, sorry, I didn't realize how close I need to be. So, and you also have the fact that Facebook is the internet in Myanmar. There's nothing else. And then to complicate matters further, the Zweige font that they use is not a Unicode font, so you can't, as an outsider, try to come in and translate. You have to actually rely upon native speakers to go in and manually read all the content. So I don't know if that's tackled in the book, but I'm very curious as to all of your views.
Everything is in the book. It's short, but it tackles everything.
Hi, I'm Peter Mesek. I'm with Access Now. Happy to co-sponsor this event and also teach a class at SEPA, which doesn't have a textbook yet. So, yeah, well, you might get some orders from the library. So, now that I buttered you up, I guess I was wondering about two different issues that I've been working on a lot lately, which seem like kind of edge issues, but I want to really find a way to tie them into these kind of larger themes about the intersections of tech companies in the sector and kind of societal interests and democracy. And the two issues that one was named was internet shutdowns, which are these intentional disruptions, connectivity often during vote counts or large public protests, sometimes to, it seems like, cover up atrocities like in Sudan over the last few days. And the other issue is this pernicious kind of targeted surveillance technology that's that a lot of states are using to persecute, harass, and get more information out of especially journalists and human rights defenders that they disagree with. And both of these are pretty targeted events undertaken by officials, often with some collaboration from the private sector. But it seems like to me that larger states, the great powers, don't really have a deep interest in cutting off or drawing a red line against either of these sets of tools. The U.S. just reached across during the midterm elections and shut down part of Russia's internet at the research unit that was, maybe responsible for a lot of the disinformation. So the U.S., will engage in targeted shutdowns. Certainly, a lot of surveillance tech companies emanate from the EU. So both these issues have, deep ties to, what seem like these liberal or whatever Western states, even though maybe the most acute impacts are on the edges. So I was wondering, if you could speak to that. And I know David's done a lot of research on the latter topic, so thanks.
Hi, my name is Neil Feldman, and I am neither a technologist nor an attorney. I was trained as a foreign policy wonk. I was with a think tank in D.C. Then I transitioned to be research director of a hedge fund on Wall Street till I was bombed out by the people I knew about earlier on 9/11. And I've reinvented myself as an arts journalist, which is very not political. However, all habits die hard. I think about a lot of these issues all the time. And now in terms of the issues, two related questions of free speech on the internet controlling it. One is that traditionally, legitimate police departments, not only in America, would do phone wiretaps for the sake of solving crimes. And as a layperson who's not an attorney, I find it hard to understand why, again, legitimate law enforcement is somehow denied access to locked cell phones, smartphones, when there is evidence of a criminal act, be it murder or whatever else? And why is it so horrible for legitimate law enforcement to be able to access that information? Will the internet fall apart if criminals' phones are tapped or opened or whatever? And and that relates to the other issue of of companies like Facebook and Twitter and the First Amendment. Well, last I checked, Facebook and Twitter are private companies. And where is there any type of either legal or moral obligation for them to permit hate speech? I don't understand that. No one has explained that to me satisfactorily. And the crap that has been alluded to by every speaker before me about the nasty stuff that happens on the internet. Why do Facebook, YouTube, and Twitter have to broadcast this?
Great, thanks, Neil. And thanks, I appreciate that the questioners are trying to keep your questions short. We will go over time a bit. And I apologize to people. We recognize some of you will need to leave, but we do want to hear the responses. So Jamil, please introduce
Thank you,
yourself.
Sandra. And we're also happy to co-sponsor Jamil Dakwar from the ACLU. So thank you, David, for other speakers as well. One of the questions that I had was already addressed is the issue of, U.S. First Amendment law and the rest of the world in a way. And, if you're taking human rights law, how do you, I think you elaborate on that, if you can say more, particularly as to what happens in the U.S. context. As you know, particularly with content takedown, is that the most marginalized, and we see voices are usually the ones that are being, burning they're feeling it more than others, particularly when you see, when you give Facebook or other groups like this powerful tool and being the arbiter, So if you can elaborate on how your vision around that and how to and the other question was really is about how something that's happening in other countries where Facebook is being sued, and they have to, if there are rulings and decisions, they have to abide by the laws of those nations, and they have to comply. So are you having a situation where some countries, where some people may have more protections than others by Facebook, due process more, take also content takedown as an example. In Israel, there's a case now where Facebook is also being sued. The Freedom of Information movement filed an amicus brief where they're arguing that Facebook should be considered as has a dual status as a quasi kind of government actor as far as its power with content takedown. And that means that they have to provide more due process, more transparency, and so forth and so forth. But if that ruling goes forward, Facebook has to comply in that jurisdiction, and what happens in other jurisdictions. So what's your thinking of that? Because it might be on the other side of positive thing. We've always looked at ICCPR Article 19. There's international law is one, and the implementation differs. The protections depending on the governments and national laws, right? Now you have Facebook, which has a more say and could actually, if they say, well, this is our understanding of Article 19, this is how we're going to behave, and they could potentially, if they do it right, based on what you're saying, they could potentially do even better job than what we were trying to do with the ICCPR implementation for many, many years, particularly in countries where they have more power. That's still debatable if that could work, but it still opens the door for a lot of power for this. So just a few thoughts. Thank you.
Yes, last
I dropped the mic.
And maybe just hand the mic.
Is it working? Hi, my name is Bill McGowan, William McGowan. I'm a journalist and an author in New York here. I've written about a couple books that bear on the subject of free speech. I'm working on a story for one of the more prominent journalism reviews, without tipping my hand. And it's about the traps that journalists, newsroom managers might try to become aware of going into this election cycle to avoid another quote unquote epic fail. Looking at we're not looking at polling data and the problems of predictive modeling, but we are looking at memes and themes and various, how they get played out in day-to-day coverage in an election cycle, particularly a divisive one. David, my question for you is, this period of regulating the internet very much sounds like it's a work in progress. It's going to be herky-jerky. It's going to be on the run. Protean might be a word. Chaotic might be a word. I would like to know, in terms of journalists approaching the issues that sandbagged us last time, vis-a-vis social media, Twitter harassment, et cetera, and monitoring online hate, what ideas you might have for me to go back to my editor to make this time well spent here. But I specifically, you mentioned you were at the New America yesterday. They have a program in conjunction with the ADL, and they have an online dashboard for monitoring online hate. I've been monitoring that. It seems now to have been kind of, it's not really up. And a lot of the point of that project seems to be identifying sources of not online hate as much as dissident political opinion and information. And a lot of it seems to bear on the issue of link shaming. And given the fact that some of these monitoring projects are in conjunction with organizations like the Southern Poverty Law Center, the ADL, who kind of have spotty records on their dedication to free speech, I'd like a comment on that if you could.
Great, thank you. Well, I'm not going to try and summarize those questions, but I'd like to start, Lynn, with you in giving some comments, and then Misha, and then give David the last word. And thanks all for staying with us to the extent that you can.
Yeah, I will again be, sort of very quick on some of this. One of the other models that I've certainly been thinking about a lot of how to of regulating or not regulating Facebook, at least domestically, is to consider it, and other scholars have been talking about it too, but to consider it really the new mall, the new public square, and to therefore say it is a public square. It's a private company. We're gonna take it over, and you cannot do anything other than a reasonable time, place, and manner restriction, period. You can't say, I'm going to go shoot Lynn Oberlander. That falls out of protected speech, and you can't do that. But in some ways, it's very simple. Another question, I'm just throwing things out, but another thing that I'm curious about in terms of sort of the federation and the lot of different voices along these lines is that where people were talking about is I think what Reddit does, which they have a lot of communities, all of which have their own moderators and all of which have their own rules. And so it is ultimately governed by some set of some policies, but they have a tremendous, right, there's a lot of diversity of opinions and of rules within that, and I'm curious about that. There is and this is in some ways a question in response to Bill and to Jamil's commentary. I also wonder whether another thing that we should be thinking about as a solution or a partial solution or is making anonymous speech a little more difficult. Not that you get rid of it, because it's hugely important. We have constitutional rights, and we know it's important for political speech, but that we make it a little more difficult, and therefore allowing you, if somebody is in fact doing all of this bad speech, that you can actually figure out who they are and go after them if it is truly hateful speech, and under the rule of law. And then, finally, I would just say to Neil, vis-a-vis the Apple iPhone, I completely agree with you. I'm a lawyer. Let's get a warrant. And, if you have a warrant, let's see what's on that iPhone. That's, my personal feeling. Sorry. Not that of my employer. Yeah. That's it.
Very direct. Thank you. Mishi, please.
I do like end-to-end encryption a lot, and I think all of us should. I also think that FBI is FBI. You expect smartness from them. That was the perfect case to get people to play it in a binary way. You're on this side or that side. But that's what you expect from them. I don't think that this is a reason to break end-to-end encryption. I have also lived and grown up in India, and I live here also. I know that given a chance, it's definitely a slippery slope. Governments want more than that. When I was talking about what the companies deny, I was saying metadata, which is not that you will actually break into it and look at the content. I also know that the idea of weaponizing end-to-end encryption by political parties is real. And the idea of harassment as a tool for censorship is happening every single time to drown dissent. I don't even know how many times I get threats or called upon on Twitter, things no human being should ever be subjected to, just because I have political opinions, or not even political opinions, I may have legal opinions which are not in line with somebody else. And that happens. I still believe in end-to-end encryption. I still think that this think about math will work differently for good guys and bad guys is a false argument. The question about, yes, there's Fourth Amendment. It works with certain rules. Governments try to circumvent all of those rules also in many parts of the world. I think the question which you raised about that platforms prioritize disinformation, sensational stuff over journalism is the very crux of it. Behavior collection, what you do, how you do, what you buy on Amazon, Google knows it. I mean, duh. And so the fact that the business model, which was your point also, is so tied into advertising behavior. It's always, the more you behave, the more you give the machine, the better it wants. We let them create programs which are going to addict our children, addict us. And we say, yeah, too bad, it's okay. We never talk about those things in the same way in these debates, but those are important. And business model, this surveillance capitalism does feed into all of these questions about free speech and expression and how we think about these issues. I have no solutions, or I have legal solutions and opinions about them. But I do say that David's approach about recognizing all of them and yet pushing for free speech and expression rights of the users and how the society thinks about it, and not just from the point of view of technology and technology companies and government, is so important. That's why I buy the book, buy many.
Good, clear, simple message there. So David, great. Please, let's hear the last word from you.
Okay, so I just want to first say that, I'm sure that many of you both attend panels and sit on panels. You probably sit on panels. A lot of people in this room sit on panels a lot. And once in a while, like while you're sitting, you actually learn a lot. And this has been really great for me because I've learned a lot just sitting up here. Anyway, so there's no way I can respond to all of the questions. They're really fantastic questions. So I just want to make a few points, partly in response to questions and partly just maybe inspired by real questions. So one is actually going back to a previous iteration, and it's a point that I was inspired to just, I just want to emphasize from Mishi's mentioning of how hard it is for the government in India to get data from the companies and the kind of barriers that are created. And I just want to, I think we need to abstract that out. And I really can't emphasize this enough. In my discussions around the world, I cannot, I can't understate, I can't overstate, I always get that wrong, how governments around the world feel so alienated from the American companies. And it's a European thing, it's Indian, it's West African, I could just go down the list. Government, part of, I think, the underlying push for regulation, it's not only on the merits, it's also this sense that these companies are doing things, and not only doing things in a way in which they seem so bureaucratic and powerful, but they also seem to be both distant and difficult when it comes to actually being responsive to government demands. And that's not just the authoritarians, that's governments that have genuine, legitimate law enforcement reasons. And so a lot of the a lot of the argument, a lot of the regulatory move, I think in part is driven by this sense that these companies simply don't have their interests in mind. And that's like an epic fail, if we want to put it in those terms, for the companies. The fact that they've been unresponsive is just, I think, a huge problem, and now we're sort of seeing the implications of that. So I'll just mention a couple of the things in response. So I think it was Catherine who mentioned Myanmar, and so one point about Myanmar that I think is really useful, and somebody mentioned this at an event yesterday, which I think is actually important for us to think about, is that Facebook had all the information. I mean, they knew, and there's good reporting on this, they had information as early as 2015 as to how the platform was being used to incite violence, not just in some kind of generic sense of allowing hate speech. Like, they knew that members of the Tatmadaw, the military, and that particular monks were actually using the platform to incite ethnic violence, and they did nothing. So this isn't like, there might be a sense in which I'm giving the companies a pass, and that really, I think we need to highlight that particular example, because it's not just about changing their rules, and it's not just about their enforcement. It's actually doing the right thing when they're faced with some real issues. So I want to connect that to, I think it was Neil's question about the First Amendment doesn't apply to companies. I don't know, maybe it didn't. There you are. If you left, I would have just ignored it right at that point. No, so there actually is. There's been a movement over the last 20 years that really picked up steam over sort of late 2007, 8 through 2013, to call out particularly to multinational companies that they have responsibilities under human rights law, maybe not obligations, and many in this room might know it as the UN's guiding principles on business and human rights. There is a set of responsibilities, of standards that have been adopted by the Human Rights Council as basically steps that companies should take, both to evaluate the impact that they have, that their activities have on the human rights of the public and their users, because it's not just a digital thing, it's a general thing. But also to take steps to mitigate and to remedy those kinds of problems. So this is in part, and I think also Lynn's point about almost like a pruneyard kind of approach to thinking of the companies in certain circumstances as like a mall, providing a kind of public space, which, by the way, in Packingham in the US Supreme Court, Justice Kennedy's evaluation, his opinion actually suggested he's not there anymore, but suggested a kind of attraction to the idea of the companies as a public square that has a kind of different set of obligations than they might otherwise have as purely private companies. So anyway, there's law developing. I think we're in this kind of intermediate phase right now where it's unclear where that's heading. But I think many of us as advocates, and many people in the room as advocates, are actually sort of pushing in that direction, that companies of scale like this do have these kinds of obligations. A kind of traditional way of thinking about companies as First Amendment says Congress shall make no law, so it doesn't apply to companies. That's I wouldn't say that's outdated, but it's not really responsive to the current environment. And so there's actually quite a lot of change taking place. I also wanted to connect your point on encryption to Peter's question about internet shutdowns and other forms of speech restriction. So from my perspective, and so the book is solely about what we think of as the content layer, right? Without getting too wonky here, but other layers of the internet stack, other parts of internet infrastructure are also really used in intense ways to limit expression, right? So there's internet shutdowns. There's, in Russia, there's the SORM. It's this device that basically hoovers up all the traffic that passes through the internet in Russia, and it's sold throughout Russian or former Soviet space, let's say. And So these are real tools for restricting expression, and I think they're just as serious, and because they are so connected to government repression, in some respects even more serious than some of the issues we're talking about. I mean, I don't want to do a comparison, but I don't exclude them in my own thinking about the future of freedom of expression online. It's just that in this particular moment, I was kind of focusing in, and the relationship to encryption. So, I mean, I'm with Mishi on this. So, and the problem with the encryption, it's not that we don't want, the FBI or other law enforcement to have access to information where it's legitimately sought through, normal law enforcement channels. It's the fundamental problem is a technology problem. It is a math problem, and that is that nobody has come up with an acceptable solution to provide access to the good guys, and I think Mishi was alluding to this, access to the good guys that the bad guys can't get access to. So it's very difficult to say, oh yeah, law enforcement should have access to this information, but do that in a way that ensures that the bad actors never get the access to that information. And I could go on and on about encryption. I mean, it's a great topic, but I just to point out that I think it's one of those ideas and issues that lends itself, unfortunately, to absolutes. Like you either have it or you don't. You either have digital security or you don't. And the trend around the world is to undermine encryption, really for purposes of repression, not for law enforcement purposes. And so I think this is just something that has to be part of the mix. So the last thing I'll say, because there were so many great questions, or I want to go back to Alex's question at the beginning of this round. I mean, I do think, so the current public debate over antitrust is I think, kind of primitive. But I think your point, and it goes back to other forms of, breaking down the business model by giving users more autonomy. Like I think that is a real attractive way to think about. It's not just breaking up the companies, but breaking them down. The concept of breaking them down and bringing them closer to users and closer to communities so that communities can have more, and this is tricky, like to give communities more ownership without allowing governments to capture that process. I don't know the solution to that, but I think your point is heading absolutely in the right direction. It is a direction that means that there needs to be regulation that is particularly focused on consumer rights and the business model of the companies and advertising, and I think that is a totally legitimate route to go down. I don't address it in the book. I mean, everything is not in this, Mishi. It's next book. Yeah. Thank you so much for all these comments.
Well, let me thank you all, and of course to thank the speakers here. The book is available from various local bookstores. See what you can do to avoid buying from one of the 4 big tech companies, name not to be mentioned. But let me just conclude with this one thought about really the nuances of human rights law, and that's one of the big takeaways that I've gotten from this talk, that we're not talking just about a free zone for free speech, but that human rights law does provide some guidance. And this book does provide some really interesting pointers. Thank you. Thanks, everybody.